Fans of the U.S. Constitution pride themselves on the concept of balance of power among the three branches of government.
The legislative branch can raise taxes, amend the Constitution, and enact laws. The executive branch can veto them, control the military, and appoint judges. The judicial branch can declare laws and presidential actions unconstitutional and can overturn amendments.
It's these checks and balances that make sure no one has ultimate power. But throughout our history, presidents have been trying to stack the court in their favor. Fans of baseball will appreciate this next analogy. If politics are like baseball, the teams would be the White House and Congress, the bats and balls, legislation. That leaves the umpire, and Chief Justice John Roberts says that's where the Supreme Court comes in.
Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire.
Currently, the Supreme Court has 6 conservative judges and 3 more liberal ones. According to SCOTUSblog, 43% of recent cases were unanimous. 15% of the cases were ruled along party lines, with the 6 Republican-appointed judges voting one way and the 3 Democratic judges voting the other, which is why presidents try to stack the court. History fans, like my producer, are going to like this next part. It all started back in 1801 with what's called the Midnight Judges Act. They were called that because President John Adams was said to be signing their appointments at midnight prior to President Thomas Jefferson's inauguration. Congress added 16 judges to change how federal courts worked. Keep in mind there were only 13 at the time, and that included the Supreme Court. And with just 19 days left in his presidency, John Adams quickly started filling those spots, with members of his own party, of course. The changes were short-lived as the bill was repealed a year later, but the politics were far from over. Fast forward about 40 years. President James Polk appointed his campaign advisor to the Supreme Court. In 1869, Congress expanded the Supreme Court to 9 justices. The following century, President Franklin Roosevelt tried to add 6 more justices to the Supreme Court after the court struck down much of his New Deal plan, but that didn't happen. Enough history, let's skip forward a few decades to modern times. Researchers from William and Mary University, along with Ohio State University, said the politics of the Supreme Court have grown in the past decade, saying, quote, presidents, for the first time ever, make ideology the dominant factor in appointing justices. The Senate confirmation process, too, pays increasing attention to ideology, including party line votes that block the consideration of judicial nominees.
It's the hallmark of the kind of judge I have tried to be.
In March 2016, Merrick Garland shed tears as President Barack Obama announced his nomination to the Supreme Court. Except Republicans held the Senate, and then Majority Leader Mitch McConnell decided Garland wouldn't get a confirmation hearing, with it being an election year and all. The libertarian Cato Institute calculates 60% of justices have been confirmed under a divided government. Garland would not be one of them, and so the politics continued. While campaigning, then-candidate Donald Trump spoke about the Supreme Court at a debate.
I want to ask you specifically, do you want the court, including the justices that you will name, to overturn Roe v. Wade, which includes, in fact states, a woman's right to abortion?
Well, if that would happen, because I am pro-life and I will be appointing pro-life judges. President
Trump confirmed 3 justices while in office, even in an election year. President Joe Biden may confirm a few as well. Justice Stephen Breyer is 82, and some progressives want him to retire so Biden can fill his seat with a younger person. And Biden is considering expanding the Supreme Court. In April, he called for a 6-month study to look into it.
All eyes will be on the court this fall as abortion rights return to the docket. The court will be hearing a case from Mississippi which could ban abortion in most cases after 15 weeks. Did I explain this well? Dare I say, hit a home run? Let us know in the comments below, and be sure to rate this story on the bias meter on our website, straightarrownews.com.